Hello, everybody. My name is Lacey Folsom, and I am discussing Title IX laws and how they apply to student affairs practitioners. First, we need to discuss what is Title IX. So in 1972, Title IX was introduced under the educational amendments that were through the Civil Rights Act, including Title VII and other items that really focused on discrimination and what that looked like in an educational setting or a workplace. The Title IX is enforced by the Office of Civil Rights, and it is impacting any education program or activity that receives federal assistance. This is quite a few different areas, including all your K through 12 public schools and about 5,000 college and universities that are considered public. Private schools don't necessarily always have to fall under Title IX because they're not receiving federal assistance. However, many still practice it for their students and their employees. Title IX is a law that mandates non-discriminatory actions based off of recruitment, admissions, counseling, financial assistance, athletics, sex-based harassment, including forms of assault or sexual violence. The statute also protects against anyone interfering with investigations or related findings, including intimidation of anyone involved in the investigations. Its relationship with higher education is that all public colleges and universities must implement Title IX laws on their campus. This has resulted in dedicated Title IX coordinators or investigators and other administrators that ensure campus remains safe for all community members. Many of these offices are part of student affairs divisions and provide support services to all members of the university community. A Title IX professional usually is a staff member whose role is to provide support to complainants who are the person who experienced harm or identifies as a victim or survivor of sexual misconduct. They also support the process for respondents who have allegedly been involved in Title IX incidents as perpetrators. Those terms, as well as others that may be used throughout the presentation, are due process, referring to any concern with procedure rather than substance. Cross-examination, which is when both parties are questioned after the investigator's initial findings, the opportunity to go back and ask questions. And an injunction, which is when a court order requiring a person to do or cease doing a specific action. As I mentioned earlier, a complainant is similar to a plaintiff, which are the people who bring a case against someone else. And then a respondent or defendant is a person who is being sued and or accused of an action. We'll also discuss how different cases are presented to different courts. So just a review of those federal courts is that you start off with a district court, usually where trials are held. Circuit courts is the first level of appeal, and there are 12 circuit courts in the United States that are organized by region. And then ultimately the final level of appeal is a Supreme Court. Now each state has their own individual Supreme Courts, but federally there is one single Supreme Court. The first case I want to review talking about Title IX is Doe versus Baum. So in this case, there was a pair of college undergraduates, a male and a female, that engaged at a sex at a party. And then 2 days later, the female filed a sexual misconduct case against the male. So the college did an investigation and found the female showed no outward signs of incapacitation, and the case was dismissed. The female then appealed. A hearing committee was created to review the appeal, and they reversed the decision of the Title IX office. In the process of this, the male had assumptions that he was going to be suspended and withdrew from the university while simultaneously suing the university for failure of due process. And then went to a circuit court who then found for the male on the male's behalf. Now, the implications of this for student affairs and in law and policy in general is first policy. Within higher education, there's a level of precedent now. Now we're looking at something that, because it happened, we can now use that to refer to it in the future, which is what precedent is. The inclusion of cross-examination became a standard for hearings. For this case, is one of those landmark cases that is used for the reasons why cross-examination was reintroduced into the Title IX process, as well as a discussion about respondent rights, which is now included in all Title IX policies that, again, are under federal assistance. Now, precedent in the law overall, not just in higher education, is that due process is more, people are more aware of it, and it's defined and clarified a little bit more throughout different laws and practices and different levels of courts. The issues that impacted higher education is definitely the concept of male bias. This actually made national news as a Me Too movement came out from our females, resulting in also a movement from our male students who say that they, through their actions, say that they are not given due process because there's an implicit bias against males, assuming that they are always the perpetrator. This really became a discussion at higher education where we were then able to talk about students' rights, making sure that both the complainant and the respondent knew what their rights were through the entire process so that there would minimize bias. Another case similar is Doe versus Texas A&M University. Also college undergraduates. The male was accused of sexual misconduct and removed from extracurricular activities, specifically the Corps of Cadets, which is a popular organization through Texas A&M University. The female, who had been previously investigated for a sexual misconduct as the perpetrator or as the respondent, who had not suffered similar consequences during that situation, nor during the current situation as the complainant. The male was hospitalized for depression in the process of this, in which they notified Texas A&M University, and the Title IX office continued to do investigations despite the male not being able to be in attendance because he was hospitalized, again, for mental health due to the issue. So the findings were that the university found that the male would be suspended for 1 year and was dismissed officially from the Corps of Cadets, which was the extracurricular. The male then sued for disappropriate sanctions, saying that it was too severe. And then the court found on behalf of Texas A&M University. The male then, of course, appealed, and then the court dismissed the suit, claiming no due course of law violation. Now, this is important because the note from the judge in the circuit court where this appeal happened is that it's not that there was a wrong or a right, it's that this specific case is not law, that this is a policy within the university but does not violate actual laws, which shows that there's implications and the idea that the policies within higher educations don't necessarily mirror law, which is good and bad, but it is difficult because representatives of Title IX offices have to function very similar to lawyers, where they're investigating and adjudicating as a lawyer would in outside of higher education, except they have only the power within that the students have on campus, which is then just suspending them or removing them from campus, no jail time. That all has to be done through a court. So this was an interesting landmark case when we're discussing Title IX, because again, is it against the law, and how is a issue that happens on campus then impact future law cases or similar law cases? The precedent and policy is that we're again talking about respondent rights. What is that implicit male bias? And do both parties, both complainant and respondent, feel like they have a ability to have their side of the story heard? And also clarifying our response protocol, making sure that there was a lot of discussion that this was a response to an issue that was happening with another large institution within the state, and that there is a specific response protocol, and that it's not just the university overreacting to a situation, which is what the media had kind of added to this conversation. Issues is, of course, equitable actions across the board at higher education. There was introduction of rubrics that were used by Title IX offices, hearing committees, implicit bias trainings were increased. Overall, a discussion about how males are involved with Title IX, and we really saw an increase in consent campaigns where Title IX staff went to fraternities, for example, that were all male gendered activity organizations, and discussed what is consent, and let's have a conversation about the role of oftentimes the respondent in this issue, which again is male bias. And so this can be very cyclical. One of the other law cases is Bostock versus Clayton County. While these were not specifically in higher education, it is very much a landmark case for transgender. And it's a Title VII case that's actually been used to discuss Title IX policy. So I felt it was really important to share. So in this one, a male employee claimed to be fired for being transgender. Overall, had hired as a male, but then later told their employer that they were planning on working and living full-time as a female. And then it was after they joined an LGBTQIA plus baseball league that they were fired, and the county claimed that it was for conduct unbecoming of a county employee. So again, Bostock was claiming, what is this unbecoming conduct, and making them define what that looked like. The findings again were Title VII, so very similar, though many of the Title IX and Title VII policies mirror each other, which is, it has been presented in front of the U.S. Supreme Court and is currently still being heard. But the implications of this is that HR and Title IX offices have to collaborate because the two policies mirror each other. And Title IX does cover university employees because they also are part of organizations that are federally assisted. The precedent in law is that this has been used as a precedent in multiple cases. It's still ongoing, but it's definitely, again, a landmark case. Overall issues as far as practicality for student affairs practitioners is that we're discussing transgender equality and what that looks like on different campuses and how it's different by different regions, and if whether or not nationally the debate is whether or not that should be even a discussion. This is also part of the arguments that are based off of specific gender use for bathrooms. And this is the case that they're specifically using whenever having those arguments in court. There was a injunction by the President Obama, and then his team had an injunction that were fighting transgender rules in different states. President Trump came in and changed that and stopped the injunction, and now we're restarting the injunction under President Biden. So presidential involvement still plays a really large role in this, which is impacting higher education institutions as we go through back and forth on what exactly is the guidelines versus the laws that each individual institution has to follow. And then there is Lewis versus LSU. So this is a case about employees. The employee, a female athletic director, assistant director, claimed that LSU was aware of and did not act on multiple claims of sexual misconduct by the head football coach. Also claimed that he and other staff failed to report cases that they were aware of. There were Title IX cases, and that all of this resulted in a hostile work environment. The policy review was done by Hush Blackwell, who is a prominent law firm that specifically works with Title IX cases, amongst other things. And they found that there was the policy at LSU had major flaws, the Title IX policy. It continues to remain in court, and there's currently no decision. But it was interesting to note that the Lewis is suing for $50 million, which puts a number to a financial number to similar cases, which is really kind of a precedent in its own. The precedent and this is for policy, is the implementation of responsible employees. In Senate Bill 212 is the law that said responsible employees will be terminated or jailed for failure to report, which has then sparred into an applicable issue of responsible employees and doing trainings and reviewing those protocols at the university levels, so that university employees are prepared to report and also understand how to report. Overall, the student affairs application is that student affairs practitioners are often the staff that students interact with regularly on campus, and they're likely the ones who are going to hear this content. And so it's important that they receive adequate training, specifically those student affairs professionals who have daily interaction with students. The intention of these new laws as they continue to evolve is that it will likely increase the number of reported cases, which will also have the procedural implications of university staff finding the staff to investigate investigate and adjudicate under these new federal standards properly. And student affairs staff, which often includes Title IX administrators, must communicate with university legal counsel and administration to ensure that the students and employees know the Title IX laws. And in closing, just remembering that students come to a university with the expectation that all campus community members will uphold their basic need for safety. And it's imperative that training and resources for staff are provided to contribute to faster response rates and a more equitable process overall. And these are my references. Thank you all so much.